Tell you for a fact that this election is between.
They sold form recently for 100 million.
There's no meaningful development that can happen without peace, without us being united.
Arrest all unregistered vehicles.
I think we have shown the depth and breadth of talent in our Conservative Party.
A situation whereby that powdering substance will be flushed immediately.
Thank you so much for still sticking around with us. It's Straight Talk right here on Bright Television, the home of talk and entertainment. Don't forget that the program is basically designed to look deep into issues that affect Nigeria as a country and Nigerians as citizens as well. In this particular segment of the program, we'll be looking at the role of the judiciary in Nigerian politics, and of course we'll be looking at the case of the Senate President versus Mr. Macha. Mr. Macha actually lost the battle at the Supreme Court. The Apex Court affirms the Senate President Ahmed Lawan as the Yobe North APC senatorial candidate. Well, in the judgment, lots of technicality issues and of course oral evidence were not well presented by Mr. Machen, and of course many other legal practitioners have said that it's a case that Nigerians must really look into. But in his reaction, the Senate President spoke to the pressman and was happy about the judgment which his party actually took to the Supreme Court. Let's listen to him. We'll be back with our guest to look deep into this.
Let me start by thanking Almighty Allah for his blessings, and of course what has happened today in the Supreme Court, the judgment on Yobe North particularly. It's a victory for all APC in Yobe and generally APC across the country. What happened was democracy at work, and the courts gave their various judgments, and of course the Supreme Court gave the final judgment. I want at this point to commend the Supreme Court and in fact the judiciary generally for making this kind of judgment to strengthen our democracy, because it's not only for politicians to work and strengthen democracy, it's for all of us, and all the institutions have some roles to play. So I commend the Supreme Court and the judiciary in general. Let me take this opportunity to thank the All Progressives Congress, the APC, our party, for taking this matter to court, to the Supreme Court. Actually, I didn't, as a person, as an individual, go to the Supreme Court to seek for a redress. But my party did, and my people, the people of Yobe North and Yobe State generally, and many.
Well, I speak from the Senate President. You recall that the Supreme Court has finally recognized the Senate President Ahmed Lawan as the authentic candidate of the All Progressive Congress for the Yobe North Senatorial District. And to discuss these and many other issues as regards to the judiciary and of course the role they play in Nigeria, I have a legal practitioner, a member of 2014 National Convention, is a delegate of the 2014 National Convention, and of course a public interest and development lawyer. I have Barrister Godswill Iyoke. Thank you so much for joining us on the
Yeah, thank you so much. Good morning. My pleasure of being
and I should
here.
say Happy New Year to you.
Yeah, same to you,
Good to see
and
you
good
again.
morning, Nigeria.
All right, let's get into the conversation. It's no more news. It's a fact that the Apex Court have recognized the Senate President to be the candidate of the APC in Yobe North Senatorial District. It seems as if this also the same thing played out in Akwa Ibom North East Senatorial District, where we also had the former minister former governor of Akwa Ibom State, of course, Mr. Akpabio, Godswill Akpabio. It's Akpabio's case. The party went to court again, to the Apex Court, to see how they can get the judgment. Eventually, the Apex Court gave that particular judgment. This particular issue, same thing. According to Senate President, he said, well, it's the party, and of course, he's happy with the judgment. What exactly is happening to the judiciary system in Nigeria?
Yeah, thank you so much. I think that's the question, not what's happening to judiciary in the country. I mean, it's what is happening to the nation. The only difference here is the fact that judiciary seem to be on the spot for good reasons. And I think the positive side of every situation raises the good, the bad, and ugly sides. And the positive, I would like to start from the positive. The positive aspect of this development is that hitherto, like the kidney or the heart, which are vital organs in the body, but hidden and concealed within the human anatomy, human physiology. The flesh covers it, they are hidden somewhere, you don't see it, but they are very critical to the functioning of the body. Sometimes when you see a person ailing physically, you see a person frail, eventually you might discover that it could be one failing organ or the other, either the kidney or the heart. And of course, these are very fatal, of course, very mortal organs in the body. That's why care is taken. And I think until now, many had ignored the judiciary. And as a lawyer, I want to say that the most important organ of the state, the nation, is the judiciary. Judiciary, as people say, the hope of the common man, is there for everyone, and is the symbol of democracy. It's not the legislature, it's not the executive. The symbol of the democracy, the symbol of a functioning state. As a matter of fact, the state of development of any nation is a function of the health of the judiciary itself, the judicial organ. It determines it because that is the melting point. That is where all issues, either interpersonal, intergovernmental, between government and persons, on any issues are resolved. It's a place where sense is brought in, the law is brought in, things are interrogated, and it's an organ of government, an organ of the state that is the most cheaply available to everyone. If you have a complaint, you can go to court, pay a little fee, you have access. But sometimes it's even much more expensive for you to reach your legislator who represents you, even in the parliament. It's not everyone acts, operates, or have access to those who are in the executive. So judiciary is actually the point at which you find all issues resolved. Oftentimes, the state of the nation, the way people feel, if they are aggrieved, is you go to the judiciary, you find out the level of issues, causes of action that are brought. You could use it to measure or determine the temperament or temperature of a given state.
In fact, one of your colleagues has said that judiciary is the last line of defense in democracy, which
and you see, it's not just the last line of defense, it's the main line of defense and offense.
Okay, in this case, in this particular case, let's look at the case of Ahmed Lawan. Of course, Yobe North, let's put it that way.
Yes, I was actually coming that way. I usually laid the foundation for where I was going. Now, the issues here, well, yes, Ahmed Lawan is a citizen, like every other person, like the defendant or respondent in that particular, on the controversial suit. Both of them are citizens. The only difference is that Ahmed Lawan, within the socio-political setup we have in our system, is a strong man. is a powerful person. Is somebody the head of up until now legislative arm of government. So he's the head of one of the organs of government of the state. So it's a very powerful person in relation to the other person. But both of them are party men. And in your foundation introductory talk, you had mentioned other cases, that of former governor of Akwa Ibom State, the same seat, senatorial seat, and the former governor of Ebonyi State, both of whom were all governors, heads of the executive arm of government, powerful people in their own right. So you are dealing with a situation where you have very powerful persons in whose favor this decision have been taken, and that is the reason some of the things that has made matter a little more controversial. All of them had the matters resolved in their favor, despite the fact that different issues were raised by each of those three parties. But ultimately the matters were resolved in their favor. But what is certain right now is that we are sure, by virtue of the decision of the apex court, the candidates are going to represent those constituencies at the Senate. But what is not certain right now, and the base upon which I believe amongst others have been brought here, is the position of the law. The position of the law is not clear.
Is the position of the law?
The position of the law is no longer clear. But meanwhile, before now, two of these personalities were members of legislators. They made input to the Electoral Act, upon which the decision, some of the issues are raised in these particular issues are raised.
The critical point that the Electoral Act is also going to be talking about, even when the election is held. Talking about the duration, the time frame of INEC, submission of any name from a political party, all captured in the Electoral Act that we are talking about now. How do we?
That is the point. You see, that is the point. With the basis of the law are principles. Law are basically principles to guide our conduct. It can't really tell you, the specific thing you need to do. It guides you. Don't go this way. If you go this way, you violate it. Your action becomes illegal. It becomes a nullity. You can't enforce it. That is the basis. That's the basis of the law. It's certainty, and the purpose of certainty is order in society, so that people will be guided in what they resolve to do. But when you find a situation where the law is no longer certain, people are not sure what it is, there won't be respect for order. There won't respect for it. Anybody does what he likes, believing that when I get to court I can have my way. That might be the impression created just now. But on this particular matter in question, the latest controversy, raising this controversy, that we have not got the full judgment. Incidentally, those of us who are stakeholders, not just stakeholders, we are I would want to say members of the caucus, I would say lawyers are, because we are supposed to know the law. Yes. We are supposed to be familiar with the reign of the judicature. The jurist that delivered the lead judgment is a respected jurist. He's not a frivolous jurist. He's somebody that when you look at it, when you want to understand philosophy of the law, in certain respect, you read his judgment. He's a jurist whose judgment lawyers take interest in reading, because when you read it, it opens your eyes. The frontiers of the law is open. So that is why not many people be quick to condemn it. Otherwise, when you look at it from the face of it all, the first thing it throws at you is contempt. How could such a thing be? Why is it so? Because of our understanding of what the law had said. What was the position of the law before now? The position of the law. What's the position of the law before now? The position of the law, as understood by many, even as lawyers, is that if you participate in running for a particular office, you have brought the nomination form, you are taking part in a process, you can't go back to another. In this particular situation, that we learned, as it were, by facts that were presented, not disputed, accepted facts, that the person of the state president had run for the office of the president. He had sought nomination. He ran for primaries. He went through the process. He lost out. He now came back. And after the primaries for the Senate had been concluded, and a person, the outcome of it, a person was nominated, who was the respondent at the Supreme Court decision. He came back and they organized another, allegedly organized another, which ordinarily he was not qualified to participate in, even if there was a legitimate primary, second primary. He wasn't qualified to participate in, having participated in a previous one. Yes, he went in the court. Mind you, this matter is pre-election matter. There are matters that are pre-election, other matters are post-election. You are not really looking at the Electoral Act. We are really looking at the law itself. You understand me? We think that should regulate, affect the action, activities of election participants. So this is the position at that time. He wasn't supposed to be. He wasn't qualified to run. And after that, when the party, when he now ran, the person went to court, and the court really found out, look, you are not supposed to be. He went to the court of appeal. So the two courts, the court of first instance, the appellate court, found the same. Reached the same conclusion, dismissed his appeal. At some point in time, it was reported that he said he was not going to appeal.
He also mentioned that he wasn't going to appeal. The party actually went to the Supreme Court.
So he raised another issue.
To appeal that.
Yes, he raised another issue. The issue now that he raises, because the party says, the law is this. It's a party that nominates. I wouldn't know if the party has signed the nomination form, presented the respondent, Machina, to INEC. Because INEC is bound to respect that nomination. If the party had not nominated that person, the implication is that they cannot. The implication is this: having not nominated that person, the implication is that they cannot. They can put anybody forward. But it now lies. The controversy is going to arise.
So we have a pre-election.
Yes, a pre-election.
You think there's going to be a post-election case here?
Yes, it might arise, but usually, most times, some of these things are determined on some technical reasons that becloud the real justice of the case. Otherwise, I foresee another controversy, because if he's presented by the party, assuming Machina was not presented, they take it as a permanent. A lot
of questions to ask you.
A lot of questions.
Time yes, yes. What happens to the 29 days notice to INEC from any political party? Because even after this case was being mentioned, the judgment by the apex court, the 29 days was not enough. It's not even up to 29 days. That's another question. And of course, the issue of the oral evidence, that many people have said, well, that's part of the technicality that made Machina lose this particular case. Many people have said it's also part of ways many politicians use in dragging, wasting time in court cases.
Well, the question is this: you see, they are usually matters of law. They are procedure, whether they are procedural. They are procedural rules that guide actions. Those are guided either by rules of court, practice direction, what we call practice direction, and of course the law itself. In this particular case, INEC has guidelines. They are part of the from which court develop not judgment now, what do you call it, practice direction. You practice direction, whether the Federal High Court. So when such matters go on, this is the way the court, the processes, the procedure that the court should adopt. But that does not on itself foreclose the use of the normal rules of court when it comes to matters that affects the rights, what people consider to be their rights under the law, not necessarily their electoral rights. You understand me? This one is a pre-election matter. We are determining what is their right to contest election. So those ones are guided by the procedure of court. And if the process itself, the process will tell you some of those. But the question is this: what were the issues that were supposed to be addressed? There are some matters you can settle by way of affidavit. There are some matters when there are controversies, you call for oral evidence. The question that would arise, whether in the process of exchanging arguments by way of affidavit and counter affidavit, were there issues that arose that were not resolved, that were supposed to have been resolved orally, that were not? And if both parties agreed that, okay, this particular matter, we can resolve them by way of affidavit evidence, and call by way of originating motion, originating summons, because originating summons or motion presupposes that you are foreclosing oral evidence. So to what extent are the other parties affected? If what the procedure both of you have adopted has not in any way, is not in any way prejudicial to your rights, why would you complain? And if you have not complained, why will the court be the one to raise a complaint?
Well, interesting conversation.
So yes,
interesting conversation. But time will not permit us, to talk about that. Section 135, subsection 3, also allows the president to actually extend election if he has reasons to do that. And many Nigerians or many political parties have been calling for postponement of election. A quick reaction to that. Do you see that happen?
I wouldn't see it happen, but it's expected. I mean, the point, some people are doing out of mischief. Those who are not ready, those who never wanted it. There are people who do not even think that the government should leave. If they say third term, they like the government to continue. The one, because they are either stakeholders or benefiting from it. But the question is, if there's any reason for postponement and the president accedes to it, it's an admission of failure. You couldn't keep the government, you couldn't maintain law and order in such a situation to present the right atmosphere for certain things to be done as scheduled. It's a measure of failure, and I don't think the government should accede to it.
All right, thank you so much. Well, a legal practitioner, and of course, 2014 National Convention Conference Delegate and Public Interest and Development Lawyer, the person of Barrister Godwin Iyoke. Thank you so much for joining us.
Thank you so much, my pleasure.
All right. My name is AYOBAMI ADEYEMO. Like I always remind you, I keep telling you, when you play your part, I play my part, we have a better place. The Republic of Nigeria. On behalf of everyone that's been part of this beautiful episode this morning, we say thank you so much. God bless you, and God bless the Federal Republic of Nigeria. Goodbye.
Tell you for a fact that this election is between.
They sold form recently for 100 million.
There's no